Hi, my name is Carl Pearson, and I'm a foreclosure defense attorney in New York. And the title of this video is New York Foreclosure Defense Strategy. And it's something that I have put together because of my experience during the past 7 years and new developments in New York. And I wanted to explain for all people who are facing foreclosure in New York what I think needs to be done, what they should do in order to maximize their potential in retaining their property. So for the past 7 years I have been going into the New York courts to stop foreclosures, and things have been changing. And here is what a threatened homeowner should consider doing. And I say consider doing because every case is different. And what I say generally about defending foreclosures may not apply to your case. And you should speak with an attorney about the specifics of your case for that reason. Now, having said that, let me talk about the three main parts of the foreclosure process that I'm going to discuss, which are: 1, realizing that you are in financial trouble and what you should do about it; 2, the second shoe drops and you are served with a summons and complaint and what you should do about that; and 3rd, the New York, quote, conferencing, unquote, process and how you should use it to your advantage. For most homeowners who understand and apply what I say when appropriate to do so, remember, as I have discussed at the outset, the foreclosure crisis will come to an end and you will remain in your home with an affordable mortgage. This is what happens in many cases when these things that I discuss are done. So, part 1. I'll start with the first part, realizing you are in trouble and what you should do. Once you realize that you can't keep making your mortgage payments indefinitely and that at some point you will run out of money, you should bite the bullet and stop paying your mortgage. Now, I realize that people will say, well, won't that affect my credit score and other things, your interest rate? Yes, but you are going to be facing that by definition, that you know you're going to run out of money and run into that trouble in a few months, maybe even a year from now. But I am saying that it's better that you should do it now. Bite the bullet and face that right now. Stop paying your mortgage, and the benefit to you in doing this is that you will be in a position to pay a lawyer to guide you through the foreclosure process, ending hopefully with an affordable mortgage. If you continue paying and you don't have money at the end because you've given everything to the bank, you won't be able to hire a lawyer, and therefore you will lose the property by defaulting on your mortgage. And this will encourage the plaintiff, which is either the bank, the loan servicer, or maybe an investor in the note. It'll discourage them from giving you a loan mod if you don't have an attorney, and they're not going to give it to you usually if you don't have an attorney, for reasons that I'll explain. So try to set aside as much money as you can during this period, because you want to be able to put up a good fight to defend against the foreclosure, which is more apt to result in an affordable loan modification agreement than if you have no money and put up no fight at all. That's sort of axiomatic. It's sort of self-evident what I'm saying there. Also, during this period, you probably will want to apply for a loan modification agreement after you have stopped paying your mortgage, but you are less apt to obtain an affordable modification agreement at this point, mainly because you are not yet in litigation, and there is less reason at this point for the owner of the note to reduce the amount that you will pay under the note. Part 2. Let's go into Part 2, where the New York homeowner mortgagor receives a summons and complaint in a foreclosure action brought against him by either the loan servicer, the owner of the note, or which might be an investor or a trust, or a major bank as trustee. And in an increasingly number of cases, unfortunately for the homeowner, we find that venture capital funds and hedge funds, private investors, and vulture funds are purchasing notes up more and more, often they're doing this for the purpose truly of foreclosing and throwing the homeowner off the property, and not to give them a loan mod, because they're not in that business at all. So that's just an unfortunate development that we have to contend with. The most crucial decision you will make is the hiring of a lawyer quickly, so that the lawyer files a timely answer with counterclaims and affirmative defenses to the foreclosure complaint, and that you do not wind up in default. That is so critical. I cannot emphasize how critical and important that is, to file an answer, a good answer, on a timely basis. 20 days after the service of the complaint, if it was served personally in New York. In one county in New York State, the local judge told me and the bank's lawyer recently that 99% of the foreclosure defendants failed to answer the complaint. Now, this might have been a slight exaggeration by the judge, but I'm telling you, not that much. The judge was serious, and I believe it's somewhere in that area that most people I know don't respond to the complaint properly. They let it go by default, and they lose their property more likely than not as a result. Most homeowners defendants don't realize that there are many defenses that can be raised to almost any foreclosure action, even if you do owe the money. Even if you do owe the money, there are many defenses that can be raised, valid defenses. And that failure to answer the complaint on a timely basis is generally a waiver of most, if not all, of those defenses, and a disaster from a legal standpoint, with the homeowner probably going to be thrown out of his or her home after the undefended foreclosure process is completed by the bank and the court. If you don't defend the action on a timely basis, the bank will be less interested in giving you an affordable loan modification agreement during the so-called, quote, conferencing, unquote, period, which starts shortly after the lawsuit has been commenced. During this conferencing period, which is a settlement negotiation, as people think, but not really, there's no real settlement discussions there, the plaintiff and the homeowner try to see if a loan modification agreement, or perhaps a short sale in some cases, can be worked out. But if you have not defended the action on a timely basis, the bank and its attorneys will know that, and they will deny you a loan modification during the conferencing period, as a result, and the referee will then terminate the conferencing, and who has no power to direct the bank to provide any relief anyway, and the bank will then be free to complete the foreclosure process because you have failed to defend the foreclosure action on a timely basis. In other words, because of your default in failing to answer the complaint on a timely basis, the bank is entitled to get an order to sell your property at auction because you are in default in the litigation, and have no right to defend the foreclosure action, even though you do have defenses to it, in spite of the fact that you owe the money. Remember that. It's all very complicated, convoluted, but you can owe money to the bank, and the bank still has to comply with very stringent foreclosure requirements in order to have a court order that your property be sold. Now, the way of taking advantage of that is by forcing the bank to meet all these legal requirements, and it's difficult. The bank has a tough time doing this, and you should exploit that and try to get a loan modification agreement as a result. This is why it is imperative that you defend the action on a timely basis with an experienced foreclosure defense attorney, so that the bank knows at the conferencing period that it will not be easy or inexpensive to get a foreclosure order, so that the bank will be better off giving you, during conferencing, an affordable loan modification agreement and ending the foreclosure action at that point. When selecting an attorney to defend the foreclosure action, you should ask the attorney about the affirmative defenses and counterclaims he or she would make, to see the range of the attorney's knowledge about foreclosure defense, and ask him or her about conferencing and how it should be used for the homeowner. Ask him or her about his experience with bad faith hearings, and ask about the person or persons who would assist you in preparing your application for a loan modification agreement, and finally ask what percentage of his or her practice is devoted to foreclosure defense. The answer will surprise you in many cases, and you'll find out that your attorney probably doesn't have the litigation skills that you really need in order to have the best chance at preserving your property. So more than 90% of my work is in foreclosure defense, by the way. Now let's go to part 3, the last part. The conferencing period of a New York foreclosure action is a critical part of the foreclosure process and needs to be used appropriately by the homeowner's attorney to be able to have the best chance of obtaining an affordable loan modification agreement for the client. As I said before, the referee has no power to direct the bank to give you a loan modification. He or she is there to move the conferencing along, which is a series of conferences with the referee to advise him or her on what the parties are doing to try to resolve the case without a foreclosure and sale, such as by giving an affordable loan modification agreement, by arranging for a short sale where the owner generally is required to leave the property and part with its ownership of the mortgage property, or possibly a deed in lieu of foreclosure with the owner leaving the property, or possibly to arrange for a discounted payoff of the note or mortgage, in which case the owner would remain with the property, presumably. To remain in the property through an affordable loan modification agreement, which is the objective in most cases, the homeowner will have to apply once again, even though the homeowner may already have submitted many prior applications for a loan modification agreement. Don't get discouraged, don't get turned off, don't get huffy and say, I'm not going to do it again. That is short-sighted, ridiculous, and you lose your property if you come to that conclusion. This one will be different, however, because it will be made through your attorney, hopefully by someone highly experienced in making these applications, to give you the best chance from a financial presentation standpoint to show that you fit within the 31% limitation generally set by the bank, which means that no more than 31% of your income can be devoted to servicing the mortgage. And the application goes for the first time to the bank's attorney, who has a professional duty as an attorney quite different from the non-attorneys who previously dealt with your numerous failed applications in the past. The attorney will not give you as much runaround as previously, and the application will be submitted fully and more quickly directly from the bank's attorney to the lender's loss mitigation department for a decision. In New York, there is a statute, CPLR provision 3408F, as in Frank, which requires the bank and homeowner during this conferencing period to negotiate in good faith, and any unreasonable delays by the bank and unreasonable requests for information and repeated loss of documents and an unreasonable denial of a loan modification agreement can result in a bad faith hearing and a defense to the foreclosure action, even if you owe all the money. The experienced attorney will try to get you a loan modification agreement during this conferencing period, and at the same time try to develop evidence that the bank or servicer has been acting in bad faith and to try to get a bad faith hearing. There are various defenses now that I've come up with recently, in which it is pretty clear to me that there is bad faith in virtually every conferencing session because of the practices of the banks, which constitutes an important part of your defense. You should make sure that that is part of your defense. This possibility encourages the bank to give a loan modification agreement, whereas with a similar application without conferencing, the bank may not have granted such a modification. If a party tries to do this pro se, that is without an attorney, or tries to do this without an experienced attorney, the bank's attorney will recognize this and understand there is nothing to worry about, and can decide not to grant a reasonable loan modification agreement because there's no threat to cause any trouble after the case leaves conferencing because of the bank's unwillingness to grant a loan modification agreement. So in summary, the best chance you have to save your residential property in a New York foreclosure action is to stop paying your mortgage, to enable you to pay for an attorney, and to be able to submit a loan modification agreement. After you are sued, you will need to retain an experienced foreclosure defense attorney on a timely basis and serve an answer with counterclaims and numerous appropriate affirmative defenses. Then, When the bank or servicer arranges for the conferencing sessions, your attorney needs to help you apply for a loan modification agreement